Good afternoon. Let's call a meeting to order. Julie, will you call the roll?
Commissioner Schwartz.
Here.
Commissioner Peugeot. Commissioner Lodge.
Here.
Commissioner Jordan.
Here.
Commissioner Higgins.
Here.
Vice Chair Campanella.
Here.
Chair Thompson.
Here. Renee, are there any announcements?
No, Mr. Chair, I do not have any today.
Okay. This time is a period for comments from members of the public on items that are not on today's agenda. Do we have any speaker slips for anyone?
No, Mr. Chair, we don't.
Okay, we'll close that and move on to our draft minutes of February 5th. Everybody had a chance to review them. Are there any changes? Commissioner Schwartz.
Thank you, Mr. Chair. On page 6, and I briefly mentioned this to Ms. Rodriguez, under the motion of Jordan and Peugeot, I believe that the intention was the narrowing of the southbound lane on Hope Avenue and not both lanes, but perhaps staff could take a closer look at our tape on replay and decide if there was a specific identification there. But certainly, since I was the one that raised that recommendation, that was my intention. Thank you.
Okay. And Commissioner Higgins.
Thank you. On page 5, there's a reference that I support a minimum creek setback of 50 feet. I think what I at least meant to say was that I'd prefer the thresholds for unit count over setback and try to get as close to 50 feet as possible.
Julie, can you get enough information to be able to make those changes? Okay. Any other corrections or comments?
Move approval of the minutes as
Mr. Chair,
amended.
I had a comment.
Oh, okay. I'm sorry. Commissioner Peugeot.
Also on page 5, actually, in the same in the same area, creek setback minimum. Under my bullet item, Commissioner Peugeot prefers a setback of 50 feet, but would accept a setback of less than 50. Actually, what I said is it's slightly less, but closer to 50. So, thank you.
So you want slightly added?
Slightly less,
than
but
50.
closer to 50 feet.
Okay. Any other changes? Okay, we have a motion from Commissioner Lodge. Do we have a second?
Second.
Second by Jordan. Any further discussion? All in favor?
Aye.
Abstain.
Okay, and one abstention. Okay, the next item on the agenda is the project on El Encanto Road and Mira Vista Road. Staff report by Kelly Broderson.
Good afternoon, Chair Thompson and Commissioners. The project location, the project site today is located at 1800 El Encanto and 1829 Mira Vista. The site is located just north of Alameda Padre Serra and just to the east of the El Encanto Hotel. You can see here that it's surrounded on three sides by main streets, Mira Vista Road, which is a private road, San Carlos Road, and El Encanto Road, with the El Encanto just to the east. The project description consists of converting 3 existing detached residential units to condominiums. The lot is currently developed with 1 4-bedroom house with an attached 3-car garage and 2 2-bedroom cottages with an additional detached 3-car garage. No new development is proposed as part of this project. Here's an aerial photo of the site. It's a 36,833 square foot lot. It's in the Hillside Design District, and as I said, it's bounded by Mira Vista on the north and San Carlos on the east and El Encanto Road on the south, and you can see the El Encanto property on the on the west. The required applications that are under review today are a tentative subdivision map to allow 1 lot subdivision to allow 3 condominiums, and a condominium conversion permit to convert the 3 existing residences to condominiums. Just to give a chronology of the project site, the original house and garage on this site were designed by Edwards and Plunkett and constructed sometime around 1930 as a part of the El Encanto Hotel complex. The house was split off from the El Encanto in 1935, and at that time a kitchen and maid's room and bathroom were added, also designed by Edwards and Plunkett. In 1958, the private owner at the time took out 3 building permits for 2 new cottages and a detached 3-car garage, which were constructed to the east of the original house and garage. At that time, the property was zoned R3, and the minimum lot size was 1,000 square foot per unit. Then in 1979, the 2 lots at 1800 El Encanto and 1806 El Encanto were downzoned to E1. All of the structures were recently remodeled in 2012 or renovated. The renovations were reviewed and approved by the Historic Landmarks Commission and received the proper building permits. Just for some reference, here's the zoning that was allowed in 1957, and it's very hard to see, but you can see the project site in this area here. And you can see the dots. The dotted zone represents single-family zone, and you can see that the property to the north on Mira Vista and to the south on El Encanto Road were single-family, and this property specifically was zoned R3 as part of the El Encanto Hotel. This slide is also as Exhibit B in the staff report and part of your packets, and demonstrates how the existing buildings are legally nonconforming to the front yard setbacks, as the property is fronted by 3 roads. And per the Santa Barbara Municipal Code, Chapter 2888030, the condominium conversion ordinance, the requirements for a condominium conversion are that all buildings sought to be converted shall be legally nonconforming to the zoning ordinance and general plan, which these buildings are legally nonconforming. The project complies with all of the standards for condominium conversions relating to parking, storage areas, utility meters, laundry facilities, and outdoor living space. The project was also reviewed for consistency with the general plan and was found legally nonconforming to the density with 3 legal residences on 1 lot. I've provided this slide of one of the findings that will have to be made, and it just states that the proposed conversion shall be found consistent with the general plan or legally nonconforming with the density requirements of its land use element. And as I said, the project was reviewed for consistency with the general plan, the land use element, and the housing element, and staff found the project consistent and found it exempt under CEQA Exemption 15305. And that will conclude staff's presentation, and we recommend that you make the findings in the staff report and subject to the conditions of approval in Exhibit A of the staff report. We have the property owner here, Suzanne Finnemore, and her agent, Mark Lloyd, to make a presentation. We've also received several letters in support of the project, and we've received several letters in opposition of the project, which have been provided to you under previous cover. And that concludes staff's presentation.
Thank you. Mr. Lloyd, do you have a presentation?
Mr. Chair, Honorable Planning Commission members, my name is Mark Lloyd with LMP Consultants. I'm representing the applicant here today. Thank you, Kelly, for your presentation. Very thorough, complete. As Kelly had stated, and Kelly, can you bring back the first slide you had up there that showed the property? That one there. So, as Kelly pointed out, this is the property here. This is part of an old map that had split up some lots all in this area here. You can see that there is a lot line that comes down through here, and this property is made up of 2 lots in the map. All these properties over here, this one here, here, and these here were also part of a map. These lots were split by deed later. These lots were split by deed after the map was recorded. As Kelly has pointed out, in 1975, the city did a rezone on the property and zoned it to the E1 zone district, which requires 15,000 square foot per lot. These lots here are between 8,000 and 9,000 square feet. So they have a density, and that density, as I'm sure you realize, is 3 dwelling units per acre. These lots up here have a density right now of about 5 dwelling units per acre. These over in here are between 1 and 2. There's a few that get smaller here. Obviously, you have a very large lot here that is far out of that density. This one next door meets the density, and then, of course, you have the El Encanto, which actually happens to be zoned the same thing, too, and also is a legal non-conforming use within the zone district. So just to give you a feel of the neighborhood, as you have in many, let's just say, well-established and dated neighborhoods that have been around for a long time, and obviously there's a lot of beautiful buildings in this neighborhood built in the 20s, 30s, and 40s. Properties tend to be legal non-conforming, and there are a substantial number in this neighborhood. I don't want to go on too much, but many of you were up at the property on a site visit. There is no new construction proposed with the project. The project's baseline is the existing 3 density units there. There is some minor alterations that will be done to add some water meters. That's the only separate metering that needs to be done, and a couple other minor renovations. But for the most part, not much activity or disturbance, physical disturbance over the property. Also within our application, I would note that there are no requests for modifications or variances within the condo conversion. I know some of you have some good experience with condo conversions, although they haven't happened too much in recent past. I know that Commissioner Lodge has a long experience in city government. And one of the problems with condo conversions is you need to meet the physical standards provisions of the condo conversion ordinance. So many lay people may look at a property and see that it has a second dwelling unit on it. Whether that dwelling unit is a legal dwelling unit or not remains to be seen. It could be a guest house. It could be a bootleg guest house. It could be a studio or a bootleg studio. And so there's a thought that perhaps that since a dwelling unit, and I'll use that in a very generic phrase or term, exists, that these could be converted. Well, the fact is that from a legal dwelling perspective, they may not be converted. But what my experience in this arena has shown to me, it's really the physical standards provisions that really prevent conversion. You have to meet 2 parking spaces per unit. You have to have the private yard areas, not within the setbacks, but within interior setbacks. You need to meet the private storage provisions, et cetera, et cetera, et cetera. And that's why we don't see a lot of apartment units really being converted. There's just not enough room on the properties to do that. I've looked at this area on an aerial photograph, and by no means conclusive evidence, but my own experience and my ability to analyze aerial photography, and I do have some long-term experience in that, is that there appears to be some other units out there, whether they're bootlegged or not, whether they're dwelling units or not. The overriding aspect of my loose analysis would show that there's really not the physical standards criteria because the lots are just too small and too built out. As Kelly had said, there was a number of letters that were rendered today. and the ones in opposition make various claims. One of them was rather long and had a number of ordinance sections that it cited, and I would bring to your attention that the Section 28 ordinance standards about condominiums that letter alludes to is inapplicable here. That ordinance provision is for new condominiums to be done. This is a condominium conversion which has within 28.88 a whole set of different criteria. And so that is distinct and different, and quite frankly, the letter writer has erroneously added those in and made a lot of points about it. I won't get into that. Also, it's talked about the findings you need to make, and I would support that you make those findings. Kelly has listed them in your staff report. There also is raised some issues about the findings you need to make and your ability to do those in these letters, and those are generally with a general plan consistency finding. As I think you will know, that a general plan consistency finding requires that you, in my opinion, note that the spirit and intent of the general plan is carried through. There may be competing policies within a general plan. By example, a policy that says that we should have more housing, and yet a policy that says we should have less traffic. Those are competing policies, and within your responsibility as decision makers, you evaluate a project, you look at those general plan policies as they affect a project, and you make a decision as an informed decision maker. You make a balancing decision within competing policies. I would offer that more in depth that the project does meet the goals, policies of the general plan. I went through those, and I don't want to be long here. And obviously, the general plan is really written with a focus and perspective on new development and changes in our city, whereas this project doesn't propose that. But I would say that the housing opportunities goals of the housing element, where the goal is to ensure a full range of housing opportunities for all persons of all economic scales. I think that many will recognize that the two smaller legal residences on the property are just 2 bedrooms, 1,500 square feet in size, and they offer an economic opportunity for people to own in this neighborhood at a price point where otherwise they may not be able to achieve on another larger property. So I think that diversity and ensuring housing opportunities for all people. There's a goal of conservation improvement of existing housing. The goal is to conserve the existing housing stock and improve its condition while minimizing displacement and preventing future blight or deterioration. This applicant's gone through a expensive renovation, adaptive reuse of the property, and has supplemented that goal. Regional cooperation, jobs, housing balance. And I can go on and on, even a implementation about continue to implement the municipal code's condominium conversion ordinance to provide opportunities for entry-level home ownership in a variety of locations. As we all know, general plan policies, goals, and objectives tend to be broad, can be subjectively or objectively interpreted. And I would say to you that it is your job, again, to balance competing policies, goals, and objectives within the general plan. I would just lastly state to you that there are other elements within the general plan, as you well know, utilities, parks, transportation, air quality, et cetera, et cetera, et cetera. The overall, I think, purpose and intent, goals and objectives of those elements are that we limit increases in demand and limit impacts. And the baseline for this application is that there is no new construction, no change in the baseline, and so inherently it is not increasing demand or increasing impacts. So all of these more functional elements of the general plan, I think, are also met. And so therefore, I think that you can, with a great degree of comfort, make the necessary findings to approve this project. Thank you, Mr. Chair. I'll stop at that. I'd like to reserve time to rebut any other testimony. And I'm here to answer any questions you may have.
Okay, thank you. Do any of the commission members have any questions for staff or the applicant? Commissioner Higgins.
For the applicant, Mr. Lloyd, could you put up the exhibit that was displayed during our site visit that shows the different, maybe not, or maybe you can. Just question on
Yes, that one there.
these are airspace, and is that common area owned by the HOA? There's no HOA, there is an HOA. Give us just an overview of the property line boundaries and the mechanics of the map.
Mr. Chair, Commissioner Higgins, glad to. As well, depending on how versed you are in condominiums, they're regulated by the Davis-Sterling Act in the state of California. And the act was originally constructed to where you had airspace condominiums. You basically owned to the paint on your walls. And in fact, it's interesting, the first condominium project in the state of California was Montecito Shores in the county area. But anyway, in 1987, Davis-Sterling was recodified and allowed condominium airspaces to contain air, water, and basically redefined the definition of land. And so since 87, this is where you've seen sort of the development of condominiation of boat slips, where you can sell a boat space that's full of water, mobile home parks, you could sell actually the space that you park your unit on, et cetera, et cetera, et cetera. And you're seeing what, and Jay, I know you have some experience of the zero lot line kind of projects and whatnot, where they could be condominium spaces, where the condominium area actually includes more than just the interior space. And so our notion of this condominium would be one that has, here's the units themselves, the three of them, and then the 2-3 garages in the office. And what we were going to create as the condominium unit is what you see here for this one in the blue hatched area, for this one, which includes the garage, in the magenta hatched area, for this one in the red hatched area, and a little bit of blue for this guy over here, and here for his or her parking area. And then the green hatched area would be the common area within the condominium development. So setting up these spaces, we felt, gave a sense of privacy, open yard area, and other amenities that were consistent with the characteristic of the neighborhood, but also allowing unrestricted open space for ingress and egress, access to garages, offices, parking, laundry, et cetera, et cetera. So that would be their exclusive use areas within their so-called unit. But within that, we would also have provisions that allow there to be common maintenance of the entire exterior, including the building, so that there would be CC&Rs that would assure that the qualities and finishes, the drought-tolerant landscaping we had, would all be maintained as an obligation of all of the owners in the condominium project. And there would be association fees and HOA that would do all that.
Who owns the ground?
The ground would be owned by the homeowners association. And their unit, and Davis-Sterling makes this distinction between the interest you own. It's not an easement, but the condominium interest you own can be full of wood, dirt, water, air. And so the interest would go to the heavens and to the depths of the earth as an interest, but the land is part of the association. A typical condominium setup.
Does that get it for you, Commissioner Higgins? Commissioner Peugeot.
Thank you, Chair. First of all, I wanted to ask, is this just our beginning questions, or you want all our questions?
No, do you have any questions for?
I have a list of questions, but you want them all now?
Sure.
Okay, all right.
Our normal process is get the
Okay.
questions out.
I have questions for staff. And my first question, I guess my first question has to do with the findings. I'll start there. So we need to make findings under the Chapter 27 subdivision regulations, and we need to make findings under the zoning code, the section on condominium conversions. That's my understanding. And in looking through those, there's a slight differences in what each of those findings say in those codes. So I would like it if staff, or perhaps it's for Mr. Vincent, to elaborate a little bit on those findings and how we get from the current existing conditions on the ground with this project site and its nonconformities and get to the place where we can make a decision on those two different findings.
Over to you, Mr. Pinson.
Thank you, Mr. Chair and Commissioners. So you're correct that there are two different sets of findings, and I'll focus your attention particularly on the general plan density finding. The requirements, the findings required for the tentative map are found in Section 2707-100 of Title 27. They do require a finding, the Planning Commission to make a finding of consistency with the general plan or any applicable specific plan. Regarding findings of consistency with the general plan, and as Mr. Lloyd pointed out, the general plan has a broad set of goals and policies, some of which are complementary, some of which conflict with one another. When considering a consistency finding with the general plan, I take some guidance from a 2011 case, Pfeiffer versus the City of Sunnyvale. And this language is also quoted from several other cases throughout the state, but this was a very good and concise rendition of how planning commissions and city councils are to conduct themselves in finding consistency as well as their discretion to do so. So under the government code, every city and county is required to adopt a comprehensive long-term general plan. The city's land use decisions must be consistent with the policies expressed in the general plan, and the propriety of virtually every local decision affecting land use and development depends on consistency with the applicable general plan and its elements. An action, program, or project is consistent with the general plan if, considering all its aspects, it will further the objectives and policies of the general plan and not obstruct their attainment. State law does not require perfect conformity between a proposed project and the applicable general plan. In other words, it is nearly, if not absolutely impossible, for a project to be in perfect conformity with each and every policy set forth in the applicable general plan. It is enough that the proposed project will be compatible with the objectives, policies, general land uses, and programs specified in the applicable general plan. In this case, the City of Sunnyvale was considering a redevelopment of a hospital, and part of that hospital's improvements were going to be placed on land zoned as a single-family zone. In its review, the Court of Appeal addressed the applicable standard of review and said, when we review an agency's decision for consistency with its own general plan, we accord a great deference to the agency's determination. This is because the body which adopted the general plan policies in its legislative capacity has unique competence to interpret those policies when applying them in its adjudicatory capacity. Because policies in the general plan reflect a range of competing interests, the governmental agency must be allowed to weigh and balance its plan's policies when applying them, and it has broad discretion to construe its policies in light of the plan's purposes. A reviewing court's role is simply to decide whether the city officials considered the applicable policies and the extent to which the proposed project conforms with those policies. A city's findings that the project is consistent with its general plan can be reversed only if it is based on evidence from which no reasonable person could have reached the same conclusion. Thus, a party challenging a city's determination of general plan consistency has the burden to show why, based on all of the evidence in the record, the determination was unreasonable. I generally, as you know, don't speak this much in our meetings. But I did think it was important, given the questions that we've seen from the commissioners, as well as the issues raised by the members of the public, to carefully frame your determinations today. And I understand that there's a potential conflicts have been raised with the framework of your decision today. I've gone back and, to the best of my ability, tried to resolve those conflicts. It's our goal to, when potential conflicts exist within the municipal code, the purpose is to give effect to all of the language as much as possible, and to interpret them in a manner to resolve the conflict as opposed to create the conflict. In this particular case, we have a condo conversion ordinance. We also have a separate ordinance in a different title of the municipal code that concerns the development of condominiums. The condo conversion ordinance was originally adopted in 1979. The ordinance and chapter dealing with the development of condominiums was adopted in 1980. They used two different terms to describe the activities occurring or being regulated. Chapter 2888 regulates condo conversions, the conversion of an existing dwelling unit to a condominium unit. Title 27, Chapter 13 regulates the development of new condominium units. And the fact that they use condominium development as the term and did not use condo conversions, those two terms exist independently within the municipal code. The condo conversion ordinance came first. Development of condominium units came after. Presumably, the city council, particularly given the fact that the contemporaneous nature of their adoption, 1979 to 1980, I have to think that the city councils in question, whether they're the same members or even different members, it had to have been fresh in everybody's mind. And possibly Commissioner Lodge could even enlighten us of that circumstance. But they used different terms. They placed the regulations in different places. They cover chapters 2713 and 2888 cover much of the same ground. They both specify development standards. They both specify, they identify similar but slightly different findings that are required for their adoption. And so with all of that understanding, I see that they're intended to exist independent of one another, that condominium conversions are regulated pursuant to 2888 and not 2713. But condominium conversions do require the approval of a tentative map. And that's why you see the findings from Chapter 2707-100. That section's findings are also required. And so you will need to make all of those findings in 2707-100, as well as the findings in 2888. I hope that answers your question.
Okay, did that answer your question?
Absolutely. It was spellbinding in its delivery as well. No,
And you
it
had
helped
other-
very much. Thank you.
You had other questions, I believe.
Pardon?
You had other questions,
Yes,
I
I
believe.
do. I do. Regroup after that. My next question, and I'll kind of throw it out there rather generally for staff or Mr. Vincent, has to do with the actual effect. So if this goes forward and the condo conversion takes place, gets recorded, what I'm having a hard time getting my head around is the status of the nonconformities after the map records. So we have two types of nonconformities. There's structural, which is setbacks, and there's use, which is basically density because it's all residential use. So on the first one, on structural, I imagine my question is a little bit more perfunctory in that there are ways in some portions of the Subdivision Map Act where you can change things like setbacks, and then we have a system here for modifications and whatnot. I just don't know why the setbacks then continue to be non-conforming after recordation. So that's on that part. And then on the use and the density part, that non-conformity, I'm having an even harder time understanding if we're recording a map, doesn't that make legitimate the density, particularly in this case because it's not a land subdivision, it's an airspace number of units, and the condo plan shows the floor plan and, the boundaries of the units and things like that, and that's recorded as a subdivision. So I guess I still don't get why that retains its nonconformity for the use if it's, post-recordation.
Mr. Chair and members of the Commission, I'll tackle the structural issue or the physical layout of the proposed conversion first. Section 2888030, requirements and procedures. It's part of the condo conversion ordinance. One of the requirements for a conversion is that all buildings sought to be converted on the date of conversion in all respects in compliance with the zoning ordinance and the goals and policies of the general plan, or legally nonconforming therewith. So you have to either comply with the setbacks, and I'll let Ms. Broadison comment on to whatever degree there are nonconformities between these buildings and the setbacks. However, a key point to remember is are how those setbacks are defined. The setbacks are defined by the property line. This subdivision is a one-lot subdivision. The property lines still remain on the outside of the subdivision. There will be condo units and the designation of those locations. You saw that on the slide that was shown earlier. However, the property line remains the same, and its relationship to the right-of-way, which defines at least the front and interior yard setbacks, or the front setbacks, and then the interior setbacks are set by the property lines adjacent to other parcels. So the fact that a condo plan will be superimposed on this existing lot doesn't affect where the property lines are, and therefore doesn't alter their status with respect to a setback. The subsection that I read a moment ago, as far as that all buildings sought to be converted must either comply with or be legally nonconforming to those standards, the setback standards. It carries forward, and this same section informs us how the property will function or can function going forward, saying that notwithstanding the provisions of Municipal Code Section 2887030, which concerns nonconforming buildings, any legally nonconforming building or buildings for which a condominium conversion application is approved may be remodeled or otherwise physically changed, provided the changes do not increase or intensify the element of the building that is nonconforming. So that informs for not only us but also for future owners of these condominium units the scope of potential changes they could make in the future. If, in other words, applying this to the buildings on the lot, I don't know right off the top of my head whether they are conforming right now to the setbacks or legally non-conforming to the setbacks. Let's assume one of the cottages is legally non-conforming to a setback along El Encanto. They would not be able in the future to put an addition on that that unit, that condominium unit, that would intensify or increase its nonconformity with respect to that setback. However, they could remodel on the other side, if assuming it didn't trigger some other noncompliance in the future. And so the condominium conversion ordinance anticipates these circumstances where legal nonconforming conditions exist and how those legal nonconforming conditions would continue in the future.
And the other part about the, that's helpful, thank you. I think I get it now. But the other part about the density part, the nonconforming use after recordation, and what effect does that have on the property if it retains that status, even though there's a condo map?
Mr. Chair, members of the Commission, with respect to the nonconforming nature of this property as to the general plan density designation, it currently is nonconforming as to general plan density today. This conversion, if it's approved, would not change the nonconformity. In the one sense, the property would continue at its nonconforming density. How that would play out in the future would be if one of these property owners wished to add another residential unit, the standards couldn't apply. I don't anticipate the standards, the municipal code or the zoning standards allowing such an addition at this point, particularly given the fact that it's a single-family zone at this point. But the conversion really isn't changing the property's status with respect to the general plan density. It's already nonconforming in its current condition. It will continue to be nonconforming in the future. Really, the touchstone for you today, or the decision for the Commission to make today, is whether or not, as the application is proposed to you, you can make the findings necessary to approve the tentative map, one of which is consistency with the general plan.
Okay, I just have I think one more question. Yeah. So we've seen in some of the letters that were submitted kind of this introducing a question about the current non-conforming status of the residential uses on the cottages. Like, for example, were they a guest house or were they dwellings? And I think there was some information presented in one of the letters about the buildings being vacant for certain time periods and whatnot. But I think what I read in the staff report is that the city had previously, or maybe upon this application, made a determination that those units were still currently legitimate non-conforming dwellings. And I just would like to know if staff wants to comment on that, maybe let us know how you got there, or elaborate a little bit on that conclusion.
Chair Thompson and Commissioners, I would just respond to that by saying what makes a building a residential unit would be a full bathrooms, and bathing facilities, and a kitchen. And these units historically have had full kitchens and bathing facilities, which makes them legal non-conforming units. So if a single-family residentially zoned property has a house and a garage and an accessory space, that space would not be counted as a unit unless it had a kitchen and a bathroom in it. So we wouldn't normally approve something. We would never approve something like that, actually, on a residential, single-family residential zoned lot.
So as a follow-up to that, so what I understand you to be saying is that our determinations in the city are based on the physical layout and improvements, not the occupancy or not. So it would then mean that if one of the units was gutted and they took the kitchen out and it was in that kind of a condition for a year or more, that would mean it lost its non-conforming status rather than whether or not someone was actually residing in it?
Mr. Chair. I think that's a good example of that not every non-use or not every period of non-use, and I quite honestly I don't know the factual history of the use of this property in any particular detail, but that's a good example. Let's say a property was remodeling, and we have recent examples of this where a project gets started, and for any number of reasons, it flounders, it stops, and the property remains vacant for a good period of time. Are we going to say that property, because of that condition, is no use, that its use has been abandoned, and that the property owner will have to start from scratch one to reintroduce a new use? Or let's say that make the example even more poignant to this circumstance. What if that lot was non-conforming as to residential density, yet that residence, for whatever reason, was not occupied for a certain period of time? Are we going to declare that the fact that it wasn't being used actively for the use as a single-family residence, whether it was under a remodel or let's take a case of a foreclosure? I'm sure we could find examples of residences in this community that were not occupied for the requisite period of time where you could point to them and say, that use has been abandoned because it hasn't been used, it hasn't been occupied for the requisite period of time. So I don't see that every situation of non-use constitutes an abandonment. I think there has to be some form of intent or something more than just simply a lack of occupancy to get to the stage of an abandonment. And more to the fact that in this particular case, again, and I really don't know all of the facts about it, but if any portion of this lot was occupied by an owner, simply because not all 3 units were occupied at any one time, there are rooms in my own house that I don't go into for months, literally months. So, again, I think that there is a higher bar than just a simple occupancy to get to a stage of literally an abandonment of an existing use.
Okay, one follow-on question to that. I don't believe we have seen a question of making that determination on nonconformity come to the commission, at least in the couple of years I've been on the commission. So that decision of whether something is conforming or non-conforming, how is that made? Is it a staff decision, delegated to a certain person or department, or how is that? Who is the final decision maker on that, let's say?
Mr. Chair, I'm not. I mean, I'll take a stab at the answer, but I may ask another clarifying question in a minute. In this particular case, we have a residential unit that was built on this property at one point in time, and 2 other residential units that were built with permits at a different period of time. However, all 3 units at that time were an allowed use. It was legally conforming at the time that all 3 of these residential units were permitted, and constructed. That creates the legal part of the status. Then, when the later downzoning occurred and established this as within a single-family residential zone, that's when the non-conforming status came about. So they were originally permitted and constructed legally, and then it was only the fact that the zoning changed after the fact that they became legal non-conforming because they're not conforming to the current standards. It's not so much a matter of well, I mean, I guess staff makes a determination that they were legally constructed. That gets them the legal part of it, but the non-conforming is created by the change standard after the fact. I hope I answered.
Well, I understand, and maybe it isn't a cut and dry answer. Maybe that's where you're headed with this, but it's not an application process. Let me ask it this way. I mean, to my knowledge, it's not something you apply for. I would like to apply for legal nonconforming status. I mean, in the end, I think there's a reason that you have been providing all these answers for the last several minutes, and it seems to me that in the end, there's some legal premises that eventually need to be reviewed in difficult cases and things like that. So I guess what I'm saying is I think it's a decision that really is dealt with by looking at a lot of factors, but I don't really get the idea that it's something that is a discretionary review. It's just based on judgment and knowledge of facts.
Are you asking, is the legal nonconforming discretionary? Is that what I heard you ask?
Well, okay. I thought it was actually kind of a simple question at first, but maybe it's not. It's not it's my experience. Let me put it this way: it's my experience that determination of whether something is legal nonconforming is usually the professionals in the departments making a determination, and it's not usually something that you balance according to the general plan, for example, so much like we are in a decision on a subdivision. It's not an application that then goes through review loops. It's either legal nonconforming or it's not.
Sure. Mr. Chair, members of the Commission, I guess maybe you'll be glad to know, you are not being asked to decide today whether or not the residences are legal nonconforming or not. They are legal nonconforming. That is what staff is telling you, that the record has shown that the units are legal nonconforming. What you're being asked to do today is to decide to convert these 3 residential units existing on one lot under one common owner. Can they be converted into condominium units that could potentially be owned by as many as 3 separate owners? And would your action of allowing that conversion of ownership possibility be consistent with the general plan and its goals and policies?
Okay, thank you.
Okay, is that got it? All right, Commissioner Schwartz.
Thank you, Mr. Chair. My first question is for Mr. Lloyd. So, Mr. Lloyd, if you would come back up to the podium for a moment. In your opening remarks, you mentioned that in addition to renovating the property owner, your client, also undertook adaptive reuse. Can you describe what that was? Use that term, adaptive reuse. So what adaptive reuse, a change of use, did the client undertake on the one or both of the parcels?
Mr. Chair, Commissioner Schwartz, that term is a term of art. There was no change of use. It was a remodel and adaptive reuse, meaning that remodeled bathrooms and changed them around to adapt them to the style and layout that they wanted. So it's the reconfiguration of an existing use is an adaptive reuse, in my mind. So it's a term of art. So there was a general rehabilitation and remodel done of the units.
Okay.
There were no changes in use.
Okay.
I'm sorry if I said something that was confusing or misled you.
Okay, thank you. That's my questions for you for now. Thank you.
Thank you.
Okay, I'm just going to, in no particular order, go through my questions. First, to staff, to Ms. Broadison. As you know, I sent you an email asking to understand if the significant renovations that were undertaken and that are referenced in the realtor's letter. The realtor has no name, it's just a realtor letter that talks about taking all 3 of these structures down to the studs and renovating them. whether or not all of the applicable city permits are in order for that, because I want to see if there's a clean permit history on that significant work that was undertaken.
Chair Thompson and Commissioners, yes, there was a recent rehabilitation of the existing buildings, and they went to Historic Landmarks Commission, were reviewed and approved, and received the building permits for the remodel. I actually coincidentally did a site visit during the construction with one of the inspectors before I ever even got this submittal. And I can't speak to a real estate agent's claims or any type of advertisement, because that's not part of the application or the discretionary process.
No, but we have that in our packet from a member of the public submitted that to us. So I just wanted to understand, in fact, all three of these structures were taken down to the studs. I wanted to make sure before I continue on that I understand that the rest of the property is in legal order. We're talking about legal nonconforming. I want to make sure the rest of the legal issue pertaining to the work that was done is in good order. And you're saying that all the permits have been checked as to all that renovation, and they are in order?
Yes.
Okay, because you mentioned that it's in the staff report, but when I go to page 3 of the staff report, it actually only references that the structures were renovated in 2012, but does not identify that all permits are in order. So that's why I was asking you that. Okay. So moving on, I guess, again, in no particular order, back to you, Mr. Vincent. Title 27. In a packet of information we received by a member of the public, Marcia Croninger, she references under Chapter 27.13, this is actually this is the requirements section, 27.13.050. No condominium project or portion thereof shall be approved in whole or in part unless it complies with all requirements of Title 27 of this code, etc. So that sounds to me to be all-encompassing and pretty absolute. Before I formulate any particular opinions in our deliberation, could you comment on the all?
Mr. Vincent, would you go over it again that you talked about before, about 27.13?
Yes, Mr. Chair and members of the Commission. As I said in my opening comments, condo conversions are regulated under Chapter 2888. New condominium development is regulated under Chapter 2713.
I understand. And why would this not be new when, even though the structures on the ground are not new, but converting them from guest cottages and rentals to condominiums is a conversion?
And so it's
kind of a new animal, a new housing animal, for lack of a more artful term.
Because it's a condo conversion. It is the conversion of an existing dwelling unit to a condominium unit. That is the definition of a condo conversion.
Okay.
A condominium development doesn't involve the conversion of an existing residential unit. Yep. It is the creation of a residential unit. And those are why the two animals are different and why they're regulated differently.
Okay, we then still have in this same package from Ms. Croninger a reference to that chapter, 28.15, which still references. So all I'll say is, to me, it's not clear. I know what you've said. I've heard what you've said twice, but that is not a clear alignment to me of that. So I'll just have to kind of sit with that for a while. My next question to you is, and I posed this to you in an email in advance, I wanted to know what the city's history is of approving condo conversions in the E1 one-family resident zones, to see what maybe precedent setting, comparable, that sort of thing. Do you have any helpful information for me on that?
Mr. Chair and members of the Commission, I'm aware of only one other project that has been converted to have condominium units within a single-family zone. I don't know if Ms. Brooke has any other.
No, Mr. Chair, that's the one I'm aware of too, and I believe it was zoned R1. It was approved by the Commission probably 6 or 7 years ago on Islay, East Islay.
East Islay? Any details about that would be helpful for reference today in terms of our considerations that you're aware of?
It's a project distinct unto itself, so similar findings were made at that time. It was also non-conforming to density. It was, again, existing units within a single-family zone that was non-conforming to density.
Okay. Okay, again, in no particular order. So I'm trying to reconcile in terms of this use and that there is no intensity of use or change of use, probably more intensity of use. We have the applicant's proposal for condominium conversion, 2 separate parcels, 3 units. However, at the same time, and I referenced this at our site visit, I know you weren't there, Mr. Vincent, but there's the realtor's current marketing of the property, and I think the realtor's here in the audience. I think I see her. That references that parcels, would it be B and C? Not the main house, the other 2 smaller cottages from the 1950s, are being marketed as guest cottages. And my question to you or staff, whoever's appropriate, is, in my mind, the use, intensification of use for a guest cottage is different than either continuous rentals or multifamily use. So I don't know what we really are looking at here. Are we looking at guest cottages on the one hand, which is what the owner is marketing the property to be to the market, and at the same time we have a very different application that we're considering.
Well, Mr. Chair, members of the Commission, I'm not going to speak to the methodology of marketing, because the term guest cottage, that could be a guest house, which could be an amenity of a single-family home. So I don't know if that's intended to be marketing to as a vacation rental or not. What I would say is this: you have 3 legal, non-conforming residential units on this property. They can be occupied by 3 separate families, or a combination of a single family. Each of those units exists with the current amenities that they have. As Ms. Broadison mentioned,
right,
we consider them separate dwelling units, complete dwelling units, because they have kitchens and full bath.
Right, I heard that part.
And so this property can exist today, and does exist today, as one property with 3 residential units. The 2 cottages could be rented out as long as the rentals are for more than 30 days. Those uses would be consistent with the residential use of this zone. If they were rented for less than 30 days, that would be considered a transient occupancy,
right,
and that is considered to be a commercial use, and that would not be consistent or allowed within the zone.
Right, that's prohibited in the city. Okay. Okay, thank you for that. Ms. Broadison, back to you. One member of the public sent us a letter, Janine Daniel, and she asked in this letter, so I would appreciate the answer to this as well. She asserts that the parking structure adjoining the main house is in question, was built adhering to the height and width, etc. However, she questions whether it's acceptable under today's standards and requirements. I don't know if you remember the letter that she sent. So I would like to ask you if the parking structure is in compliance with our current code and standards, or if a modification needs to be made there. Since she said they were built in the 1930s and they may not be up to current code and other requirements.
Chair Thompson.
This is the February 17th email from Ms. Daniel.
Chair Thompson and Commissioners, the garages qualifies as a 3-car garage, and I don't know what you mean by the code, but it has been reviewed and approved by Transportation Planning, also the Building Department, and it qualifies in size and dimensions as a width and length as a 3-car garage.
Okay.
If it might help, I might point out that you may recall when we were there Tuesday at the site visit, there was an SUV in the garage.
I actually didn't, the garage doors weren't opened for us.
Well, you could look in the window.
Well, yeah.
Anyway.
So anyway, that's my
for
question.
that.
I'll keep going. Thank you. Let's see here. I think I may just have 1 or 2 more. I think that's it for now, Mr. Chair. Thank you.
Thank
I may
you.
have some later.
Okay, thank you. Commissioner Campanella.
Thank you, Chair Thompson. Question for staff. Prior to the remodel taking place, just to confirm, the units had all of the features that would make them habitable as a single-story dwelling, single-family dwelling. They had the baths and kitchen area, heating, et cetera.
Chair Thompson and Commissioners, that's correct.
Okay. Question for Mr. Vincent. Since we're looking at the section on condo conversions, which deal with how to take care of rentals and what the physical nature has to be in order to convert and what type of notice and compensation you have to give to the current tenants, I just wanted to confirm that a condo conversion did not have to be of a rental project. It could be of a second unit, as we have the case here, let's say, so that we should not consider rental to be part of the evaluation, that it had to be a rental.
Well, Mr. Chair, members of the Commission, the conversion is of a residential unit. The condo conversion ordinance addresses the potential for tenants to have existed and addresses how those tenants need to be treated if they're no longer going to reside in the residential units as a result of the conversion. I'll let Ms. Broadison speak to whether or not there were tenants that are entitled to assistance under the condo conversion ordinance. But I would say that, let's say, if there was a member of the owner's family living in one of those cottages, that doesn't in and of itself make that member of the family a tenant. So, so if that addresses your question.
But it's not necessary. If supposedly if these were never rented at all in history, they can still be converted.
Yes.
Being a rental is not a requirement.
No. The units do not have to have ever been in a status as a rental unit. It is the conversion of an existing dwelling unit to a condominium unit that may be sold separately from the other residential units on the same lot in this case.
And I'm going to be hypothetical a little bit, and bear with me, but assuming this property at some prior to the downzoning or the rezoning to E1 had actually been able to split the property up into 3 lots, and I believe it conformed to everything else, but there were still some non-conforming issues with it when they were done. And there were some reciprocal easements to get to the garage and other things you would do with a map. If then the downzoning occurred, these would be 3 lots that were legal non-conforming and could be conveyed without having to make any changes on the property in order to transfer it.
Mr. Chair, members of the Commission, I understand the hypothetical. I'm trying to frame the answer correctly. If they were subdivided, the 3 lots would exist with their particular conditions. Presumably, I can only really deal with the example, or I can only give the answer under today's conditions.
Okay.
If it was possible, let's say this was an R3 zone again, and this lot exists, and 2 out of the 3 proposed lots have enough lot area, but 1 doesn't. You'd have to have a lot area modification for that lot. Or you'd have to reorient the lot lines in order to get enough square footage. So that's how that would be dealt with. If one of the lots was approved for a subdivision with a lot area modification, it would be subject to that restriction. It could not be further subdivided. So it's...
Okay, thank you. So what we're dealing with here, of course, is a situation where lot lines were never recorded for these units. So we're dealing with 1 lot that's non-conforming. And I guess the given requirements, the only way to convey is through a condo conversion. Or that would be a way that facilitates it, because otherwise it would not conform to the zoning of so many units per acre.
Mr. Chair, members of the Commission, the units could not be conveyed separately at this point because they are part of 1 legal lot. That is the lot that can be conveyed. To convey them separately by deed would be a violation of the Subdivision Map Act.
Thank you.
Is that it?
That's it. Thank you.
Okay. Any other questions from the Commission? All right. We'll go to public speakers. I'll call your name, and you have 2 minutes, and then I'll call the next in line so you can be ready to come up. Starting off, our first speaker slip is Marcia Croninger, followed by Janine Daniel. Hi.
Good afternoon, Commissioners and Chair. As we have had a lengthy discussion on various legal issues raised here, I appreciate the City Attorney's efforts to try to reconcile these ordinances. I respectfully disagree in certain aspects, specifically the attempt to reconcile Title 27, which was later enacted and certainly could be more clearly stated if the theory that the City Attorney has put forth were intended. I disagree with that interpretation. I think there are a lot of interesting legal issues raised here, including whether the approval of a condominium conversion is in itself a new use, the complexity that was described right here with this PowerPoint of the relationship that a condominium presents, the transition in use from a possible legal guest house to something that can be owned by three separate owners. All of that, I think, the checkered history of the property in terms of actual use when it returns, according to your records and the applicant's records, to single-family use for almost 4 years. Those things raise interesting and important legal issues, which obviously have not previously been discussed, and personally they are interesting to me. I would like to know what the courts think. Can we add a second story legally if this project were approved? My sense of the analysis from the City Attorney is that the answer might be yes, and that you would not have the ability to deny that. I don't know, because obviously we can't discuss all of these issues.
Okay, could you wrap it up?
One more thing. The general plan. The fundamentals of this general plan are based on living within our resources and the sustainability concept. The downside described here was to accomplish that purpose. It seems to me to be inappropriate to take a decision and reverse what Santa Barbara, in so many ways, the fundamental basis of this general plan for sustainability, for limiting, for leaving these non-conforming uses to end and meet that goal of 85,000 or thereabout population, not 140,000 when it was zoned originally and those units were built. It seems to me fundamentally contrary to the general plan in all respects.
Okay,
Thank you.
Janine Daniel, followed by Chuck Croninger.
Good afternoon. I live at 1701 Mira Vista Avenue. I've lived there for the last 15 years. I grew up in Santa Barbara. I attended local schools, and I've raised my children in that house. This area is essentially, the footprint is of single-family homes. I don't think it's in the best interest for the area, the neighborhood, the Riviera, to change that footprint. And I believe it would guarantee the influx of vehicles, traffic, and noise. Furthermore, my point about the garages not conforming to the codes, perhaps the city has measured the width and length of the garage, but I myself live in a Plunkett Edwards home. It was built in 1932. For the last 15 years, we have had to choose vehicles based on their height in order to get it into the garage. The unit that's indicated in brown and purple is divided by 2 pillars. I believe when you visited the site, you saw the SUV parked in the other garage. I would request, before you make a decision, please, all of you, go back to that site and try and get your vehicles in that original garage. It is rarely used, and there are vehicles always on that street. And if you pay close attention to Mira Vista Avenue, there is no additional parking there, unless they park directly in front of the house of the neighbors across the street. Please amplify this map and look at the homes that surround this area to the east of the El Encanto. I beg of you, please reject this request to convert this property into condominiums, because I believe it's in the best interest of preserving this very important historical neighborhood. Thank you.
Thank you. Chuck Croninger, followed by Peggy Wall.
Some refreshing general views here, no nitty-gritty. This week, the New York Times had an opinion article on 17 February about the American condominium. The author of the article talked about New York City, Miami, South Padre Island in Texas, and Park City, Utah. His conclusion is that a lot of condo conversions that is taking place in the country, and especially in more desirable second home areas, is driven by investment considerations and not housing considerations. If we look at specifically Santa Barbara with that sort of lens, we would see that Bella Riviera, with its market rate units, which are on the top, very close to Grand Avenue, and a few going down California Avenue, 88% of those that were sold to market rate interests are sold to people as second homes. You can determine that by looking at the assessor's records and see if a person has applied for a homeowner's exemption. So 15 of the 17 units there is no application for a homeowner's exemption. On Yananelli, you have a 42-unit condominium. 64% of those condominiums have no request for homeowners exemptions. On Pedregosa, you have 14 condominiums. 43% of them have no applications for homeowners exemptions. I think the pattern could be very clearly established that a condominium conversion is really not about housing. It is about maximizing your profits on resale. Thank you.
Thank you. Peggy Wall, followed by Linda Courtney.
Actually, Walls with an S. I am a neighbor. My property backs up to Mira Vista, and we thought about it, and my husband and I had questions about it, and we were just trying to think what would be the negative impact for us, because we are direct neighbors. And I can't find any, because first of all, they are not changing anything that doesn't already exist. We already have 3 residences there, whether it's rentals or whether it's owners. It still exists as, and that's why it's a conversion. And the other thing is that I want to say is there was one owner before she moved in, and the place was in total disrepair, and the grounds were not cared for. She's done a fabulous job of changing and making this a beautiful piece of property to look at now. And with an HOA, if anybody's lived with one, there are CC&Rs and restrictions, and so it actually kind of gives us as neighbors a benefit, because it could be rented anyway. But the benefit is that it will be maintained and cared for in the manner that it is now, and it wouldn't be changed. So anyway, I think staff has done an excellent job, and we are in favor.
Thank you. Linda Courtney, followed by Sandy Stahl.
Hello. I'm 4 houses away from this development. This lady is a developer. She came to my neighborhood with the intentions of being a developer. She wanted the ambience that a single-family neighborhood home provides, such as quieter neighborhoods, nicer homes, more privacy, and few to no cars on the street. There are a lot of properties in multi-zoned areas that she could have bought into and developed and made her little fortune. The very thing that drew her here is the very thing that she wants to destroy and walk away with some big money in her pockets. Condos would mean less quiet, less privacy, more cars. No family has 2 cars anymore. The average on my street, LeSwan Road, is 3 cars per home. These are single-family homes. This is single-family zoning. Now, we would have 7 to 9 cars stuck up at the end of the street. We finally got most of the El Encanto people off of there. Not all of them, but most of them. This would lower our property values, especially for me, since I'm so close to this project. They could have made that property into a primo single-family home. They had every opportunity. Instead, they wanted condos. Why destroy my neighborhood? Why not go to an area where there are condos? We bought our homes in a single-family zone. We paid more for them than in a multi-family zoning because we wanted all these things. We do not want condos on our street. Not today, not tomorrow, not ever. This is not the right neighborhood for condos. Thank you.
Thank you. Sandy Stahl, followed by Joy McKay.
Commissioners, I represented this property on behalf of the Post family when it was up for sale. They had owned the property since the, I believe, early 1950s. Mr. Post specifically purchased this property to turn it into residential income property. He not only got permits for it and built the 2 cottages, but at a period of time while they were in the main house, when he was still alive, they actually had split the main house and turned it into a duplex. So at one time, there were actually 4 residential units on that property. At the time that it was sold, it was in complete disrepair. It was leaking. There were rodents. The Mrs. Post was 100 years old, and her daughter did not have the financial ability to take care of this property. Mrs. Finnemore purchased the property with the intent of being there, staying there, and doing the condominium project, as far as I can tell, doesn't really change the impact of how this property is used from its historical use for probably 50 years now. It has had tenants in there. It's had family members. There's no way to add additional cars. Each cottage only accommodates 2 bedrooms. And in fact, in listening to the comments, the original house had 5 bedrooms. It's now a 4-bedroom house. So she's actually made it even smaller. I can attest to the fact that I have a regular-sized car, and I can go in and out of any of the garages there. They're, in fact, kind of prescient in how capable they are to take current cars. She's completely restored everything, and the way I was marketing the property then as now is those are legal rentals. There's nothing that prohibits her from having anybody she wants come stay in those houses with as many cars as they want for as long as they want, as long as it's over 30 days. So I would urge you to please consider her application. She would like to stay in the neighborhood and live in the house and keep it looking as nice as it is now.
Thank you.
Thank you.
Joy McKay, followed by Louise Kemp.
Hi, my name is Joy McKay. I've been a resident of the neighborhood for over 45 years. And the first thing I'd like to comment on is your noticing requirements. I live 2 houses away from the project, and I didn't get a notice, and I don't understand why, when there's something of this significance, the noticing requirements are more extensive than whatever they are. I found out about this from my neighbors and talking to them. So that's the first thing I'd like to comment on. Secondly, I'd like to say that I'm one of 48 people who signed a letter that was circulated amongst neighbors opposing this project. I don't think condominiums are compatible with our single-family neighborhood. So thank you for this opportunity to speak.
Thank you. Louise Kemp, followed by Rachel Tierney.
Thank you for allowing me to speak before you today. And I'd like to say up front that if anything I say in my comments seem rude, I apologize. Believe that they come from a deep-seated concern for our own proper valley. We are the house directly across from the cottages. Whatever happens to the cottages affects us. We have lived in the house continually since 1973. In the year 2000, my husband and I made the decision to remodel the house so that we could live in it into our advanced stages that we are now coming upon. During that time, we have seen the city not uphold its own decisions or the decisions of this committee, this commission, as far as construction and use of the neighborhood. Many of those have negatively affected our property. Our property value has gone down accordingly. Now, we made the decision, maybe it was a false one, a bad one, but we made the decision that this was an investment towards our old age future, and we're looking at it. We have nothing against Suzanne. Suzanne's been a beautiful neighbor. She has tried very hard to restore the property. We saw the property go downhill with the posts. We know that the reason the big house was split was so that there could be a nurse on staff for 2 family members that were terminal with cancer and stayed there. And then finally, Mrs. Post, in her advanced stage, stayed there and needed nursing care. That's why it was split. It was not split to be used as an additional residence. We have concerns with what's going to happen, not with Suzanne. We understand why she wants to do the condo conversion. She wants out from under the responsibility. She thinks and tries to convince us that everything will continue as it is now. We are concerned, and frankly, we don't trust the city to protect our property rights, our investment, based upon past encounters. The El Encano, I was before you for the El Encano not too long ago. We all know what a mess that is and continues to be a problem for us. We just don't have the confidence that if you convert this to condos and we have 3 owners to deal with, they will indeed keep the property as is. Once they put 2 and 3 stories, we've seen it happen behind us and causes problems there. According to the district attorney, it sounds like they can do that. We can't control what they're going to do. Who are they going to lease it to? Is it going to be for family members? Is it going to be college kids? Is it going to be rentals? We don't know that. Right now, it's a stable environment. We feel for Suzanne. We definitely appreciate her efforts and what she has done for the neighborhood and for that property and therefore for us. One member said that the only additional parking would be across the street. That's us. And before we could close on our house, our escrow on our house, we had to purchase or have purchased for us a portion of that street. So technically, nobody can park in front of us.
Thank you. Could you wrap it up,
Okay.
please? Thank you. Rachel Tierney is our final speaker, unless there's somebody else who wants to come forward.
Good afternoon. I'm just going to read from this. My name is Rachel Tierney. I'm a consulting biologist working in Santa Barbara for over 25 years. I live up the street from Suzanne. I'm on the corner of San Carlos and Mira Vista, and I can see her house from my window. Suzanne has done a class job restoring the buildings. From my understanding, the walls, floors, ceilings all needed extensive repairs, and the buildings were infested with rodents. She's used the finest materials, and the results are stunning and restrained. I'm against condos going up anywhere in my neighborhood. I'm against increased density. I'm against increased use. I'm against change like anything else. But I don't see any change for the worse with this project. There are 3 houses, 2 are legally rented, 1 is owner-occupied. I don't see any increase in use or density resulting from this project. And unlike many of my neighbors, I don't see degradation of the charm and character of the Upper Riviera following approval of this project. I don't want properties with little guest houses becoming condos. I doubt any could meet the requirements, but this site is unique. What I do see at this site is a beautiful property, carefully and lovingly restored from the studs up and out. I see the potential of a subtle transformation, bringing the old layout into what we live today and to how we live today, without sacrificing anything. I see the creation of a compound with 3 households that can build a special community within our neighborhood. I support this project and ask for your approval.
Thank you. That's our final speaker, unless there's someone else. Okay, we'll close the public testimony portion, and it's back to the commission for comments, unless somebody needs to take a break. Okay. Anybody have any comments? Mr. Jordan.
Just willing to sit back and wait, but I don't see anybody moving.
You want to defer to your vast knowledge.
To quick conciseness, right? So I appreciate all the discussion we've had today. I'm especially struck with most of what Mr. Vincent had to say from a legal standpoint, because that was my feelings were shared in where he led us that way too. Much of what I've heard today concerns what ifs. And it is not, I don't think it's my job to sit up here and worry about what ifs. What if somebody is renting it illegally less than 30 days? Or what if somebody has 20 cars and puts them out on the street? That's the city's job to regulate that. This is a particular land use decision, and it's clear to me that that we've determined it's legal nonconforming, that the uses that are there today are going to continue or forward. The uses that can continue forward are just there today, whether they were the owner living in it or they were 3 separate rentals or any combination of that. There's going to be no increases in those uses. And as the applicant said, they've met the tough standard of the physical standard requirements for conversion. On top of that, since it's this time and not 20 or 30 years ago, the applicant's also going to have to bear the burden of the relocation ordinance and the fees for the housing inclusionary ordinance, which I think 20, 30 years ago you wouldn't have had to do that. Much of the conversation and much of the letters have been about worries that I think could be on the ground right now, and you've equated those worries to they would only happen if these convert to condos, and I just don't think that's true. So I'll support the staff recommendation and be able to make the findings. Thank you, Mr. Chair.
Thank you. Commissioner Schwartz.
Thank you, Mr. Chair. Well, first let me say that after receiving a petition of what looks to be 37 residents, that really gets me to sit up and take notice. On any of our decisions, there are always mixed opinions in the community, and that just comes with the job, so to speak. But when there are this many number of concerned immediate residents, it really prompts me to kind of roll up my sleeves and do a great deal of additional research to find out what underlies the angst or the concern and the opposition. So to that end, I want to reference a couple of things because making the findings for general plan compatibility is something that I researched, and I just want to say at the outset that I'm not going to be able to make the findings of compatibility with the general plan. And I want to reference on page 1, starting on page 1 of our general plan, and there are many pages, but I'm going to be very brief, pages 1 and pages 5. On page 1, at the very bottom of page 1, it's sort of our governing Bible, so to speak, in the city, we have that although a significant portion of the city's housing stock is affordable to low and very low income households, few middle income affordable housing options exist for the needs of our diverse community, risking the very character we strive to retain. And we're now seeing a pattern both in Santa Barbara and outside Santa Barbara of specifically this unique housing animal called the condominium lead us in a direction that is completely divergent from what I would respectfully suggest is at the core of our general plan and of our sound land use decision-making principles. Now I'm going to go on to page 5 of our general plan under growth management. It specifically says here that there's some potential implications of continuing the current housing trends, which at the time this was originally conceived and then it was approved by the council in 2011, was leading some of the mixed-use development to a proliferation of large condominiums. Again, not supporting the kind of mid-market and more affordable, that's small A, not subsidized, capital A, affordable housing. So there are 3 bullet points on this page of page 5 of the general plan I want to reference. Continued development of large condominiums and loss of sense of community due to more part-time residents, loss of affordable housing, and it's another bullet point, and worsening jobs housing imbalance when we don't have owner-occupied, if it's a for sale property, or if it's rental, it's not with a local employee seeking residence here while working here. Worsening the jobs housing imbalance due to continuing job growth without sufficient affordable housing. So that's the general plan. Then I also would like to reference, in terms of making findings, Title 28. This is our zoning ordinance. We have a requirement in Title 28 under general provisions. It's page 542-3. And when we look at this issue of legally non-conforming use and what the obligations are of this Planning Commission in considering the continuation of legal non-conforming use, specifically under our zoning ordinance, it states, and I'm going to read from numbers 4 and 5 on section 542, page 542-3. Number 4, any part of a building, structure, or land occupied by such a non-conforming use, which is changed to or replaced by a use conforming to the provisions of this title, shall not thereafter be used or occupied by a non-conforming use. So wait a minute, we have a legally non-conforming use, but in potentially converting it to a condo, it would be a conforming use. It's residence to residence. This is what I understand staff's kind of interpretation to be as I read our documents. The next one, and then lastly, number 5, any part of a building, structure, or land occupied by such a non-conforming use, which use is discontinued or ceases for a period of 1 year or more, shall not again be used or occupied except by a use allowed by the applicable zoning. And then when I go to the rental history provided by the applicant, and that staff also provided us, the rental history does not support what our zoning ordinance requires. Let me go to the rental history. We have, in the document provided to us, in all 3 units, A, B, and C, there have been periods of more than 1 year where it says here, no rental activity, no occupancy, no rental activity. So as I read it, that would not conform with, or if I say it more dramatically, would violate our Title 28 zoning ordinance. So unfortunately today, and after much research and much consideration, I say unfortunately because if there were any way for me to support the applicant's request for a tentative subdivision map and condominium conversion permit, I would, but I cannot make those findings in good conscience and from the due diligent research I have done. Thank you.
Thank you. Commissioner Peugeot.
Thank you. The premise to some of my comments, I do have one final question on the conditions of approval, and it's section page, let's see, it's the very first page of Exhibit A, and it's section Roman numeral 1A4, order of development, obtain a physical standards building permit to perform all physical improvements necessary to bring the existing development up to condominium standards. And I'm just a little confused by that because I thought it needed to meet the condominium standards to be converted, but maybe this has to do with zoning standards versus building standards. I'm not sure. But what exactly would it be on this project that would need to obtain that permit?
Mr. Chair, Commissioner Peugeot, The physical standards permit you reference is required in most cases. One of the requirements we have for condominium conversions is that the applicant submit a physical elements report showing what portions of the property might need to be upgraded within, I believe it's the next 5 years. Goes through the different functions of the building, whether it's heating, cooling, fireplace, roof, and details what might need to be replaced in the near-term future. And if so, then that must be addressed before they can be converted to condominiums. So that building permit you're referencing could be any number of things. Now, Ms. Broadison would know more in detail what that physical elements report showed. However, because these units were just very recently remodeled, I imagine there's not too much that needs to be done to them to meet the physical standards requirements.
So is this correct? Is this my understanding? Once the condo plan is approved, you couldn't add, at least with this map, a second story or increase the square footage into the non-conforming areas without actually coming back and modifying the map itself, because you'd be changing the exterior components and enlarging the units, let's say. But if it needed upgrades that didn't do that, then it could continue on. And in this case, you would require that certain of them be done. Is that right?
Well, Mr. Chair and members of the Commission, there are two different issues going on there, but I'll answer the first issue first, which is the physical standards and the building permit that is referenced in Section 1A4. The physical standards building permit references it is a methodology that we've incorporated into condominium conversions, where if a property does not have some of these physical standards prior to the Planning Commission's action, that the Planning Commission or the staff hearing officer can require, as a condition of approval of the approval of the condominium conversion, that those physical standards are incorporated into the project and must be completed prior to the recordation of the final or parcel map. So look at Section 2888040, and I'll read the introductory paragraph for you. To achieve the purpose of this article, the staff hearing officer or planning commission, prior to the date of conversion, shall require that all condominium conversions conform to the Santa Barbara Municipal Code in effect at the time of approval, except as otherwise provided in this chapter. And the staff hearing officer or planning commission, prior to the date of conversion, shall require conformance with the standards of this section in approving the application for conversion. And then the section continues on with the various physical standards for condominium conversions. The Chapter 2888 defines the date of conversion as the date that the final or parcel map is recorded with the county recorder. So what this is doing is, and one of the example I'll give, because it applies to this project, is that the utilities have to be separately metered for each of the units. Currently, the cottages, it's my understanding that they do not have separate gas meters. They'll need separate gas meters or water. Water? Okay, so they need separate water meters. That's going to require separate plumbing, separate metering. That is one of the elements that would be within the physical standards building permit. Now, the applicant could go and do it today, could go and get a separate meter for those units today before the application, but why go through that two-step process when the Planning Commission requires the separate metering, it requires the issuance of a building permit and the finalization of that building permit prior to the recordation of the map, which creates the subdivision. Prior to that, you have a tentative map. You have to fulfill all of the requirements of the tentative map before you can record your map and actually get a condominium unit that you could actually sell separately. And so that's what's going on with that particular requirement.
Where I'm going with this is, one of the things we've heard today and in the letters, they cover several topics, but one of them is a concern of what could change and what can happen to the units once they're recorded. We heard in testimony today the idea of a second story, maybe a third story, that kind of a thing. And it's my understanding that certain exterior items would require this physical standards. If they were minor, let's say, but larger ones like a second story would probably require going back and redoing the map. But what I don't think has been, I believe that, my experience in understanding condominium airspace lots and whatnot leads me to know that, but I don't think that has been really brought up too much. And so I want to make the comment that I'm assuming these physical standard things are electricity, water meters, as you were mentioning, but it doesn't allow a second story to be built because we approved the condo. And if a second story was to be built, it would need to come back through the process.
Thank you. I think there's a question in there that I'll answer. Mr. Chair, Commissioner Peugeot, I'm glad you brought it up because it has been raised in a number of different ways and questions and concerns about what could happen to the property. And I want to just point out that in the general provisions section of the municipal code, there's a section, as it's been referenced earlier today, under nonconforming uses, and then a subsection of that is properties with nonconforming residential density, which applies to this property now and would apply to this property into the future. It would remain legal nonconforming to density. Very limited what you can do on those properties. And I'll just read some of it verbatim here. But improvements or alterations to a residential structure are not allowed if the improvement or alteration does any of the following: increases residential density, increases floor area of any main or accessory building on the lot, except garages, or increases the amount of habitable space. So they could not add a second story, could not add a bedroom, could not add habitable floor area on here because they're non-conforming to residential density without coming forward and asking for a lot area modification. That would be a completely separate action they would need to ask for. They can retain the building area they have because it's legal non-conforming. They can do minor things. They can change out windows, doors. They can insulation, foundation, structural upgrades, but they cannot expand the habitable area without a future action.
Okay, thank you. I believe I understood that, but I wanted the elaboration of it because I think it speaks to a number of the comments that we heard today. And I mean, in my view, the entire project was basically forwarded with the idea that it's going to be the same. The ownership status will change, but physically it will look the same, and I believe that to be the case. And then second comment I wanted to make really is got to do with, could you put the site vicinity map back up? Just a quick comment on there, but I think the map helps make the point. It's the first one. Yeah, you got it. Okay. Based on some of the testimony we heard earlier by Mr. Lloyd and a little bit by the staff, to me, what I would like to point out that became pretty obvious to me in looking at this map is we've got 3 units on a 30,000 square foot, something little under an acre, 3/4 of an acre, something like that site. And then north of it, we have a block of homes on single lots. And you can do some pretty easy math and figure out, well, really each of those lots, if they didn't have lot lines between them, it could be the same situation that we're looking at here, except that the configuration of this lot is different and more compound, let's say, because of that. So I don't see a problem with the density. I don't see it as a density increase. I did have a lot of questions earlier on about getting from A to Z legally in terms of the fact that this particular lot is single family, yet it's going to end up with 3 units. You know, how do we get there, and what does it mean afterwards? But I trust the good, thorough explanations by our counsel on that. And when it comes to the non-conforming status and what makes something non-conforming and when do you lose it, it's also the case in my experience that those are often difficult questions to answer about when something loses its non-conforming status. It usually takes all the huddling of the professionals and usually some legal review, which we have also had here today about that status. And it's complex. And so is Santa Barbara complex. I think some of the distinction we were talking about, distinctive architecture and the distinctive architecture of Santa Barbara earlier at our lunch meeting, and part of what makes Santa Barbara what it is the fact that we do have these older structures, and there are plenty of nonconformities. There's quirkiness, and personally I'm glad that we do see them here and there. I wouldn't want all sameness. I don't think any of us would really like that result, to tell you the truth. So I don't have a problem with that layout as well. We heard a lot of comments, as Commissioner Jordan mentioned earlier, about potential future changes in what the neighborhood is accustomed to, and as far as the type of tenancy and number of automobiles they own and whatnot. But as Commissioner Jordan said, that's the case in every project that we review, and it's just not in our purview to look into that crystal ball and decide what the right tenancy is. And so for all of those reasons, I'll be supporting the project. And like I said, I did have a lot of questions to begin with, and I appreciate all the letters. I took a very close look at them. I read all of the provisions of all the ordinances and codes, and I appreciate all the legal assistance we were given today. Thanks.
Thank you. Commissioner Lodge.
Thank you, Mr. Chair. Well, I will be concurring with Commissioner Jordan also. It's non-conforming because what the city did, and as Mr. Vincent implied, I was there and I voted to change the zoning, and I also fought during. Pardon me. So it's my fault. I know. You know, the drought was my fault. This is my fault. Okay. And during the general plan process, I fought strenuously against increasing density for market rate properties because I saw it had already been, I was aware already of what was happening, that with the condos, half of them were being sold as second units. Well, you can't change that. You can't dictate to someone to whom they're going to sell the property and how they're going to use it. If they want it as a second home, that's their privilege. I have 2 within 2 blocks of my home, and I live on the Riviera as well. These are single-family homes. They're second homes, and sometimes the owners are there, and sometimes mostly they're not. Which, if that's the case here, you're going to have less traffic and cars parked and so on. I just don't see how it is going to negatively affect the neighborhood. Thank you.
Thank you, Commissioner Higgins.
Thank you, Mr. Chair. I can appreciate the concerns brought forth by the neighbors about traffic and noise and changes of use. And I'm trying to picture myself in your shoes if I'm sitting there in my house looking across the street at a single-family home property being converted to condos, what that would do to me. And I think I'd be concerned. I know I'd be concerned. But again, as a planning commission, I don't think we have the ability to address the concerns that you're bringing to us. The vacation rental conundrum is not yet in our purview. I I can appreciate that you think that might, excuse me, exacerbate a situation that's happening statewide or really nationally. But I don't know that we can address that. With regard to affordability, that is perhaps in our purview. I'd suggest, though, that the city's doing all that they can do to increase the opportunities for rental housing right now, and you're sort of seeing that play out. So to the extent that we can do that, we will. To the extent that we can prevent condo conversions or further condo projects from happening, I don't think that exists anywhere in our general plan. So we have to be careful there. As Commissioner Lodge says, this property was the result of a downzoning, so I don't see it as a density increase or an upzoning for sure. And I asked staff earlier about what are some other ways to get at the objective that the applicant has in terms of reorganizing the property. You can't carve out a second unit under the state law, because here in the city apparently we don't allow second units in a high fire zone. If you look at how the applicant has organized the parking, it's extremely awkward, I believe, to have parking associated with separate units in different buildings. But yet the applicant is trying to comply with something that is within the confines of the existing code without coming forward with a parking mod. We're not able to get there with a tentative map, a straight lot subdivision with a lot area mod. They could probably still rearrange the property in some sort of tenant in common, or have multiple parties own those same properties and have some sort of fractional ownership. I'm not sure, but this seems like the only way to get at what the applicant's objective is, and I don't find that there's any increase in noise density or traffic. And I would add to the author of the petition, you probably did have quite a few people. And by the way, that did catch my attention too. So I can appreciate that becomes increases the level of awareness on my radar as well, to have that many people sign the petition. But the first bullet point says that the project will have significant adverse impacts on the neighborhood, including density and parking and aesthetics. And I just don't see how this particular project is going to have any negative effects on aesthetics. So I'd caution the author of the petition to be careful with that, because I don't believe it's factual. The upside, the city's getting quite a bit of exactions or conditions in the form of inclusionary housing, contributions, other sort of standard conditions of approvals, like improvements to drainage or stormwater prevention. So I think that's a fair trade-off. And the neighborhood also does get an HOA. So you could make an argument that condos might have a different set of people coming through, but I think you can also make the same argument that encumbering your property with CC&Rs and an HOA can also be a benefit to decrease some other effects that you might think are coming down the pipe. So I'll support the project.
Thank you. Commissioner Campanella.
Thank you, Chair Thompson. I guess looking at the neighbors' issues, I'm very sensitive to. Looking what occurred in the past and what's proposed for the future, I'm equally sensitive to. I think if these units were not there now, but somehow allowed to be second units, we'd be talking about a different type approach and a different feeling, not only for our regulations, but also for fairness. But they do exist. They have been remodeled. One of the only item I think I can go to the general plan, the major one, is housing for all income levels. And it's not only income, but also types of people that live here in the city. And I think the need, there is a need for all types of housing, but I think a single-story, 1,600 square foot, one level, and hopefully there's some adaptability in it. When you remodel, you've got some flexibility for older people, it's limited in the town, and especially if people don't want more than one story, if they don't want to move downtown, if they like the quiet, just like everybody else is enjoying. So I think this is an opportunity to perhaps provide the empty nester, the move-down buyer in the area that likes the area, an opportunity to live in a place that they don't have to maintain, that they know who their neighbors are. I know condo is a technical term, but I look at it more like an owner's association, as Mr. Higgins referred to, where the grounds and the environment is going to be taken care of. And also that you don't expect your neighbor to come in and try to do a two-story house next to you, even though they could in the future. So I think in my mind, if everything comes through, I think the occupants and residents could be broader than currently would take it just as a carriage house. They could be likely more permanent, fill a greater need. And for the community, you'll have an idea that things are being controlled or more controlled than they were possibly in the past or could have been. Mr. Higgins also mentioned fractional interest, and I don't want to get into. I was thinking the same thing. There's other ways where you can split this ownership up, or the property or value, and have agreements that are not recorded, not part of a map, and it's just an agreement among parties to say, let's put our money in, we'll share it. You can live here, or you have somebody else live here, and we'll split the profits after some period of time. We'll have buyback provisions or first right, and there's no control. I mean, it's just between the parties that can change it at any time. So I think this is probably the most efficient way, the most upfront way, and I think can serve the greater needs of the greater community of Santa Barbara, and at the same time allowing some level of comfort for the neighbors, knowing that the property would be controlled and properly maintained. So I'm going to be voting for the proposal. Thank you.
Thank you. Commissioner Higgins, did you have something else? No. Okay. Well, I would say that I've watched this remodel going on over the past several years, and I was very pleased to see the needed improvements and attention to deferred maintenance. It certainly has improved the neighborhood along San Carlos. Like Commissioner Jordan, much of what we've heard from folks who are not in favor of it is more what if something might happen and this might happen. But we can't base our decisions based upon that. We have to look at the ordinances and make our decision based on the ordinance. We've heard in some of the letters we received that parking and traffic would be a problem. In fact, someone wrote, guarantee the influx of vehicles, parking, traffic, and noise. But I fail to see how that can be valid since we already have residential uses there. The buildings aren't going to be any bigger. We have people living in them now, so people would still be living in them as a residence later. It's not changing the use to commercial. Someone even wrote, having the stigma of condos in the neighborhood. I would point out that 2 blocks away, you've had Casa Riviera for like 40 years. And nobody seems to be too concerned about those condos. So it really doesn't change the use and the impact of the neighborhood, but as was pointed out, by having a homeowners association that is going to be responsible through CC&Rs to maintain the property, maintain the exteriors of the buildings and so forth, the neighborhood is going to benefit from that over the long term. So I'm also in favor of approving the request. Commissioner Jordan.
Thank you, Mr. Chair. So I'll move approval of the project, making the findings in the staff report for the tentative map and the condominium conversion, and subject to the conditions of approval also as found in the staff report.
Second.
Okay, Commissioner Jordan motion and Commissioner Lodge second. All in favor?
Aye.
Aye. Aye.
Any opposed?
No.
Commissioner Schwartz is negative. Okay. This decision is appealable to the City Council within 10 days. Okay. Renee, anything further on your list?
No, Mr. Chair.
Okay. Do we have a staff hearing officer liaison report?
Yes, Mr. Chair. So 3 quick items yesterday, just about 40 minutes of hearing, not very much, and all involving minor modifications and allowances where the usual the usual issue was there before, and a window or a door was being changed. So nothing really to report out.
Okay. Any other liaison reports? Commissioner Lodge.
Thank you, Mr. Chair. The last Historic Landmarks Commission hearing, they did the, once again, working on the Museum of Museum of Art, and revisiting things that they had visited before. And they're also, the city is going into a program to do something about the news racks. There's 770 news racks in the city, and various stages of repair and disrepair and styles and so on, and they're trying to, and plan is to upgrade them and have some uniformity among them. And just a personal thing, I happened to be in the lobby at 630 Garden yesterday when the plans were brought in for 35 State Street. I've never seen sets of plans so big. They were about this big around, and as one of the people behind the desk said, they probably weigh more than you do. So, but anyway, it's good to know it's underway.
Is a news rack a place where Commissioner Jordan downloads onto his iPad? Okay, Commissioner Campanella.
Thank you, Chair Thompson. Commissioner Pujo and myself attended the Special Sustainability Council Committee meeting that's chaired by Benny White, Councilmember White, and the mayor and Councilmember Rouse were also there. The topics were really an update by department heads of about 40 or so initiatives, I would call them, that is ongoing for environmental greenhouse gas reduction. The solar covers out at the airport, goes on and on, water. But three things I'd like to touch on. One is was brought up by the Community Environmental Council representative, which I was unaware of. It's called Community Choice Program. And there's a number of communities throughout the state that have initiated this, including Sonoma, Marin County, and Lancaster. What that is essentially is incorporating renewable energy within your grid pattern, within community or broad-based community, in order to reduce your overall costs and work with the utilities to still distribute it, but you provide and supplement the energy sources that are being used. And an example would be the industrial area or downtown Santa Barbara commercial areas. What if you put all these solar panels up on the roofs and then try to efficiently work towards that? There's going to be a feasibility. This would essentially increase the green energy production from about 28% of the utility currently to about 50%. It could go higher, but sort of the break-even point is about 50%. We're almost double. This is going to be referred to City Council to fund a feasibility, and the mayor and other council members felt their role would be start talking to the other communities on the South Coast and also Ventura to see how this can be consolidated for better impact. June, were you there for the car share program? Still? No, okay. There's a car share program that's being proposed. This is a new wrinkle to it in that the vendor is actually providing the cars and also going to be paying for parking. This is being looked at. It's going to go to council to evaluate on a temporary basis, trial basis, but perhaps 10 shared vehicles will be put in downtown area, either on certain parking on streets or primarily in garages to see what type of play. You would register, pay for it with a toggle, and statistically it's felt that actually you can replace 15 cars on the road by having a car available when somebody needs it within the community. So that's being looked at. And then bike parking on Canna Perdido, the new bike station, I'll call it station there, is very well used, and some other owners also want to see if they can participate, as long as it doesn't take out any more parking spots. Is there some place to find it? But they're also underway now is 28 bike capacity at the MTD Center down on Chapala and Figueroa, which is really needed because a lot of people take their buses on the box or leave them off when they're taking buses or walking downtown. There's also another area that's looking at in the Funk Zone where it's near some high uses that are going on, but there's a red curved area that on a street that doesn't go anywhere, so it's not really serving any purpose. It's a dead end. So there may be a second spot. That's a trial period. And I think some of the vendors down there are willing to participate as well. So, and my last comment is it was nice to see a lot of young people in there. It looked like a Brent alumni meeting, I think, some of the fellows that I knew. But you have a lot more involvement, both on staff and also CEC and others. Younger people who are really interested in that really contributed. So that's good to see. Thanks.
Okay, any others? Well, thank you. We'll be adjourned, and our next meeting is 9 o'clock in the David Gebhardt Meeting Room on the 3rd of March. 5th of March, excuse me.
Not as many as itself.
Yeah, right.
Right.